Okay, everyone, it's great to see such a great turnout, and it's great to welcome Antony Whit QC, who I think I met first in 2009, when I was first getting interested myself in privacy and data protection. He gave a seminar, I remember, very memorably back in Oxford. And Antony's experience in this area goes back a lot further. I think you were called to the bar in 1983, so actually just before we had any data protection legislation, any explicit privacy legislation. And you became a QC in 2001. And really, at least since then, you've really been a leading light in privacy and data protection cases. But I'll just mention, particularly for the law and information students here, by the way, we are recording this. This is our standard practice, but the questions following Antony's talk will not be going online. CG and Facebook, which involves intermediary liability and the role of intermediaries in relation to privacy and data protection violations. The Stunt and Associated newspaper case, which involves whether pre-publication injunctions in relation to data protection should be considered valid in EU law, which is the case which is ongoing. And also, of course, a very critical case, even in next week's reading, which is the NT1, NT2 case against Google. The very first major High Court right to be forgotten case in this jurisdiction. So I can't think of anyone better to give you an insight, a practical practitioner, where the law is heading insight into privacy and data protection law. So without any further ado, over to Antony.
Thank you, David. It's always a pleasure to come back to Cambridge. I spent my happy undergraduate years here at the end of the 70s, long before the days of data protection. But I learned the importance of data protection here, not as a student when there was none, but in the 90s, representing the university in an inquiry or investigation into academic promotion. At the time, lawyers weren't interested in the Data Protection Act. It was too difficult and too boring. And Lord Mustall was the chair of a slightly acrimonious inquiry into academic promotion, where one of the participants, unrepresented by lawyers, used the subject access request provisions of the Data Protection Act to devastating effect. And I learned not only how effective the access side was, but how complicated the rights balancing was, because a lot of the documents that were obtained mentioned the data of many academics. And it pointed up the real difficulty. These days, lawyers aren't bored by data protection, or indeed privacy. It's an important area of the law. The former Master of the Rolls, Lord Dyson, said to someone in my chambers recently, just before he retired, all our cases are about information now. Information is the most important currency in many ways of the law. I'm going to talk about 4 topics. The first is privacy in relation to criminal investigations, which is an important topic that's still being worked out in the courts. The second is Article 8 and privacy rights in relation to the family, which is particularly important and often throws up some very difficult questions. Then I want to talk about a subject David's mentioned, which is important in my practice, given some of the people I act for, which is the liability of internet intermediaries for private material which has been posted online. And then I want to try and draw out of some cases in the 4th topic, the way in which privacy and data protection are converging and diverging, and some of the things you can do in one but not in the other. Hooray. So the criminal investigation aspect, when I was the age most of you are, the idea that a newspaper couldn't report the fact someone had been arrested would have been baffling to most lawyers. But one strand of the Leveson inquiry, which is what I'll mention first, opened, I think, a lot of people's eyes. Lord Justice Leveson was, of course, a highly experienced criminal practitioner, and in the police strand of his inquiry, dealt with the relationship between the police and the media. And in a paragraph in his report which began with the rather more exciting topic of taking reporters on police raids, the sort of thing you sometimes see, particularly in America, on late-night television, moved on to the impact of privacy on the rights of arrested persons. And he suggested a very limited set of circumstances in which it would be appropriate for the police to give the identities, he was talking in particular about giving them to the press, of those who had been arrested or suspected of a crime. And the only exception he identified, although albeit by way of example, was where there was a risk to the public. That was a catalyst for a lot of activity in the legal profession, focusing on the rights of arrested and investigated people for the first time. The first important non-judicial in the sense of not sitting judges response came from Lord Justice Tracy and Mr. Justice Tugendhat, who's always had a particular interest in this, after consultation with other senior judges, and in a response to a Law Commission consultation paper on contempt, adopted the words of Lord Justice Leveson, but with a helpful introduction emphasising the potential for harm of identifying people who may be arrested but never charged. And when you see it written down, you realise how obvious it is from a rights balancing perspective that that may be the case. Next came a further non-judicial document, the College of Policing Guidance, a very important document because it took Lord Justice Leveson's starting point, but set out a much more workable or fuller set of exceptions, including, vitally to anybody who, like me, is interested in freedom of expression, a public interest exception, without which this could become a very dangerous area of the law. One doesn't have to think very hard about a legal system which never allowed publicity for arrest to realise how dangerous that could be. The problem first came before the courts in a rather colourful case called Hannon and Dufour against News Group. Hannon was a B-list model, you should read the facts, they're quite entertaining, who awoke from a heavy sleep on a long-haul flight to find her boyfriend engaging in a rather intimate act with a woman in the seat behind them. And she was rather upset by that, and there was a serious commotion, a drunken and serious commotion, and she was arrested when the flight arrived in London. Captain Dufour was an Air Canada pilot who was breathalyzed as he arrived to fly a 747 to Calgary and was N times over the limit. They were both the subject of stories published by The Sun, who had bought the information from police officers. The Sun, with admirable ambition, sought to strike out the claims in privacy on the basis that an arrest was not a private act, basing ourselves, for it was I, on Axel Springer in Strasbourg, which provides quite a strong foundation, although one has to read it remembering that in most European countries an arrest is a judicial act, and therefore our own rather different provisions don't match. Antony Mann would have none of that and made the obviously correct point that whether an arrest is private depends on its circumstances. He came near to striking out the model's case because she was arrested on a plane before scores of people. Captain Dufour was arrested in the cockpit, and he thought that was a rather different matter. But he ended up not striking out either, and the law moved on. The matter was then mentioned in the Court of Appeal for the first time in PNM, which is the case we now know as Cuja. PNM, which I'll come to more in the Supreme Court, is important in this development, the law, for an observation of Lord Justice Sharp about the direction of travel of the law. Manuel Barker, who was appearing for PNM seeking to uphold the injunction, cited the materials which I've been going through, and although they didn't help his client, they did get traction before the court, and Lady Justice Sharp observed that there was a movement towards, as she put it, a more careful consideration of the rights of arrested or suspected persons. We then come on to Mr. Justice Nichols' decision in the ERY, and what happens in the next few cases is a gradual broadening of the circumstances beyond the arrest situation. So ERY was a man who had been under investigation. He'd been interviewed under caution, but never actually arrested, and he sought an injunction to stop the male doing two things, and this is quite an important point in the case. The two things were publishing information about the criminal investigation, and the second was to continue their journalistic investigation of it. And Mr. Justice Nichols granted an injunction in relation to publication, but not in relation to investigation. And for people who act for the media, that's a very important distinction, because publication raises a different set of tensions, but to stop investigative journalism prior to publication is a much, much stronger step. And it's important to pick up that nuance in ERY. We then come to ZXC and Bloomberg, and at the interim stage, Mr. Justice Garnham, who'd acted for the police in Levison inquiry, now on the bench, refused an injunction to restrain further publication. The man in question had already been named, and his name had reached the public domain because he'd been identified in a law enforcement authority document. But the man, nothing daunted, took his case to trial. It's quite rare in this field where you lose an interim injunction. And the trial was heard, I think, in January before Mr. Justice Nicklin, and we're awaiting judgment. But that'll be an interesting case because it has that added feature of the media defendant not being the first to break the identity, which is generally the way the cases work. Then another nuance emerged in AJS, for which, as far as I know, and Hugh, who was in the case, also can't find a reported judgment of it, there is no transcribed judgment. But the important thing about this case is the claimant wasn't the arrested person. Claimant's house was the location of a party, and another individual was arrested there. But publication of that arrest would have revealed the private information of the owner or resident of the premises in question, and therefore he was able to get an injunction on this developing legal premise. There's then a Northern Irish case, case that a lot of you will have read the aftermath of, but probably not the early stages. TKR, Paddy Jackson, was the Northern Ireland Rugby International, a real celebrity in Belfast. He sought, and I can't remember the name of the other player, he and another player in the Northern Ireland squad sought an injunction to restrain further publication about their arrest on very serious sexual offence charges. The judge thought it was a very finely balanced case, held that their Article 8 rights were engaged, but there was a special feature of that case, which was the Northern Ireland squad was about to fly to the US to play a critically important game, and they were suddenly left out. So the newspapers were reporting the members of the rugby squad, their names were missing, and the BBC persuaded the judge that that factor gave the Article 10 rights of the corporation sufficient force to outweigh their privacy rights in relation to arrest. The case went to the Court of Appeal in Belfast, but wasn't ultimately the subject of a reasoned judgment, because the Lord Chief Justice gave an indication, as we say in the trade, that the injunction, that the position required review. Sorry, I've missed an important stage. The judge, although she refused an injunction, granted a reporting restriction order, which had a very similar effect. The challenge to the reporting restriction order came up before the Northern Ireland Court of Appeal, and an indication was given which led to it being discharged. So there's no appellate consideration in that case. The two players were subsequently charged, and as many of you will have read, acquitted, and that led to a very important debate about whether, notwithstanding their acquittal, their behaviour made them unsuitable to be rugby internationals for their country. The next case I wanted to mention is Gisbert and France. This is a Strasbourg court decision in this run of cases. There was a fine, I think, or possibly a damages award against a magazine and which had published material from the prosecution file in an ongoing criminal proceeding. The media defendant complained that that was a violation of their Article 10 rights, but the court rejected that. But there's a rather different balance in play in that case. It's worth looking at, but the balance focuses on Article 6 and Article 10 rather than Article 8 and Article 10. Then we come to Cuja, a very important case in this area. As I said, PNM in a previous life. The Supreme Court sat in a bench of 7 and dismissed the claimant's appeal. I'll now, for those of you who aren't familiar with it, I'll just mention briefly what the facts are. This was the Oxford child sex ring investigation. Cuja was arrested but never charged. A group of other men were charged and a very high-profile trial took place. His name came up repeatedly. His name and the fact that he'd been arrested came up. Indeed, his own lawyers made an application in open court for certain relief. And so he was named in a public criminal court hearing as someone who'd been arrested but not charged. He sought, there were reporting restriction orders all through the criminal trial, which stopped him being named. But at the end of the trial, those would come to an end, that they would no longer have a purpose. So he made an application to Mr. Justice Tugendhat for a privacy injunction, so that the moment the reporting restriction dropped, a privacy injunction would prevent him being named and information about the fact of his arrest being published. So Justice Tugendhat refused the injunction. The Court of Appeal upheld that, and so did the Supreme Court. But there is a vigorous dissent. The court decided 5-2, and it's one of those interesting cases where the answer to the question slightly depends on your starting point. The majority saw the case as an open justice case. So was there a justification for interfering with the rights of the press to do what they always can do, which is to report criminal proceedings that take place in public? The minority, Lords Wilson and Carr, I think, Wilson and Kerr, saw it as a privacy of an arrested person case and looked through the other end of the telescope to see whether there was justification for naming, for outweighing his privacy rights. And that's, as I get older, I so often think that where you end up in your legal analysis often depends on whether you're open-minded enough when you begin it. If you start thinking the case has a particular feature or theme, you often travel down that path, whereas if you see the options at the beginning, the facets at the beginning, and travel down each path, you can find quite a lot of answers. The case is very important because it synthesizes the Supreme Court and the House of Lords and Supreme Court cases from Campbell onwards and explains the nature of the now established tort of misuse of private information. And I like the way it's put by Lord Sumption, that the law in Campbell recognised a qualified common law right of privacy, which is engaged if there's a reasonable expectation of privacy, but once engaged has to be balanced against the competing Article 10 and, in some cases, Article 6 rights. To call it a qualified right in that way fits the modern language of human rights jurisprudence and it matches the way the law had developed very neatly. So you're then, as you work from Campbell onwards, with a hiccup during the J38 litigation, Your starting point is whether there's a matter in respect of which there's a reasonable expectation of privacy. Try to give you odd insights as I go along. One thing I find week in, week out, people don't understand about privacy is the difference between the scope of Article 8 and the reasonable expectation of privacy. The scope of Article 8 is exceptionally broad. It covers everybody's facial appearance, your name, your address, but whether you have a reasonable expectation of privacy in relation to, for example, your facial image in any particular circumstance is an entirely separate question. And week in, week out, barristers go into court and say to the judge, this is within the scope of Article 8, without realising the second question is there a reasonable expectation of privacy in the circumstances? And that's a dangerous error. The majority held that because the information had come out in open court, there could be no reasonable expectation of privacy in relation to that information from that source. However, they held that because Article 8 protects your interaction with your family, your community, his Article 8 rights could be engaged because of the impact of publication, in particular on his family's interaction in the community. So even though this information had emerged in a public criminal trial, and it's an important point about Kijja, his Article 8 rights were still engaged. It's not a first-level privacy case. It's a second question privacy case. So it's a balancing answer, rights balancing answer. And what is particularly interesting is the way Lord Sumption reached back for the historical rights balancing we've achieved in the law of defamation and law of contempt, and said that the law would be incoherent if the rights balancing in misuse of private information arrived at a different result. The implications of that are still being worked out because the incoherence is manifest in several fronts of this area of the law, but he saw the incoherence as sufficiently clear there to prevent the Article 8 rights outweighing the Article 10. I think I've jumped over that. So I said a moment ago, the majority treated it as an open justice case. The minority, and it's a very interesting dissent, looked at Canadian authority and I think some other Commonwealth authority and strongly proposed that the assumption that the public understand the difference between suspicion and guilt doesn't give sufficient protection to persons under investigation. One strand of the majority reasoning was people know that not everyone who's arrested is guilty. It's a presumption of innocence. But the reality of that, particularly in the social media age, may be more questionable than Lord Sumption thought. That takes us to the last and very well-known case in this series at the minute. There are others pending. Cliff Richard in the BBC. This isn't an arrest case, this is a search warrant case. But Mr. Justice Mann, who, as we saw, decided the Hannon case, followed his own trail in and took it further. He held that in relation to a criminal investigation or an arrest, there is generally, as a matter of principle, a reasonable expectation of privacy. So there's a default rule now. There is a reasonable expectation of privacy unless there are special features, and the one he singled out was where the police identify the arrested person, which they commonly do, or sometimes do, if they want witnesses to come forward. And it would obviously defeat the interest underlying that operational policing decision if the expectation of privacy nevertheless survived. On the Article 810 balance, he held against the BBC, particularly paying attention to two factors. One was how the reporter had obtained the information. He held, in effect, there'd been a mild duping or pressurising of the police to disclose the time of the arrest. But the more important analytic point he makes is that there may well be a public interest in the progress of operational police matters, and that can be very strong, But it's an unusual case where that public interest requires the identification of the individual or individuals concerned. Now, students of this area of the law will immediately see that that throws up a problem with the pair of Supreme Court cases which culminate in Lord Rogers' question, what's in a name? Because the media are generally allowed to name people, even if it infringes their privacy rights, in order to illustrate public interest stories. And the tension between that principle and the importance of protecting the privacy rights of arrested individuals is a difficult one, and it's one which will be further explored. There are cases pending arising out of much more public arrest situations, for example in the aftermath of terrorist bombings where the police arrest someone but don't name them, and the media are reporting full steam the story, and it's of enormous public interest. In those circumstances, the balance may work out differently. Watch this space. Article 8 and family life. The critical insight is, as is often the case, Baroness Hale. In the fox hunting case, an unusual subject matter for development of the law of privacy in this day and age, but with a little thought, one can see why it raises Article 8 questions. One argument against the fox hunting ban was that it was part of the Article 8 family activities of people in parts of the country to follow the hunt, take the children out, follow the hounds. And that challenge failed, but there's an interesting Article 8 analysis. But what Baroness Hale says, it seems to me to be particularly important in paragraph 116. She divides the Article 8 protections into two strands. One is the more obvious integrity, which protects your home, protects you from surveillance by the state, those sorts of traditional Article 8 protections. But then building on the interactive protection of Article 8, she makes the point that families in particular nurture or cocoon individuals from the interference of society, and they give a private space which allows development. But it's not absolute, and this is why it comes up in the fox hunting context. There are certain things families do together which can only be done in public, and Article 8 stops short of giving legal rights to following the hunt, which you can only do in public with other people. But it's a strong observation, a helpful observation about the centrality of the family and family life to Article 8. That takes us to a case which connects both my student days, where I was very fond indeed of the Jam and waited for each of their tracks to come out. And in 1979, in Memorial Court, going underground was a great thing. So when I got to cross-examine Paul Weller, it was rather uncomfortable that I was had changed so much that instead of going into court with my Dr. Martins, I was going in with my lector. But anyway, after the case, I did get to say how much I'd admired him when I was a young man. He said, "Good on you, mate." Seemed a very nice man. His children were, as you probably know, photographed by a paparazzo in LA, down in Santa Monica. The idea, if your mindset is that of a Santa Monica paparazzo, that anybody could stop you publishing a photograph taken in a public place of a celebrity is a baffling one. The paparazzo apparently told the Paul Weller's older daughter, her name was Dylan, it's about 16 or 17, who was with his very young twins in a cafe in Santa Monica, that they would pixelate the faces before the pictures were printed. They were published unpixelated on various American websites and bought by the Mail and published with a series of captions. It's one of those email sidebar type stories that you see, celebrity photographs and captions. And Paul Weller and his wife, the mother of the twins, sued them in privacy, not on behalf of Paul Weller. It was accepted that he couldn't complain, but on behalf of his teenage daughter and his infant twins. And that raised a very acute problem of the law of privacy as we traditionally regarded it, which is what do you do about photographs taken in the street? Surely when you're out and about in public, there's a certain extent to which you haven't forfeited your privacy rights, but as Lord Dyson put it in the Weller case, you take a risk that someone will photograph you or see you and describe you. And the Strasbourg jurisprudence recognises that in relation to adults, in particular the Reklos and Greece case, it's less clear, as is almost everything in this area, once you come to children. My suspicion is the result might have been different had the only child before the court been his teenage daughter who lived in LA and was herself a model to a degree. But the presence of the tiny twins in the photographs, I think, led to an inevitable result. But it still had to be reasoned out. And since the way the law of privacy treats children is to attach their parents' expectations to them, it's the lesson from Murray. And if the parents take them out and about in public, then there may be an argument that the risk taken by the parents is a risk taken vicariously on the part of the children. The answer to that, the Court of Appeal says, is it's a family activity. And this is why it's in the family section in this case. Going shopping together with your father is a family activity which Article 8 protects, even though it's taking place in public. Quite hard to draw the distinction between the fox hunting in public and the shopping in public, one might think, particularly in Los Angeles, but that's the law, and the Supreme Court refused permission to appeal. Photographs continue to throw up problems. In an interesting Strasbourg case, there's a finding of a violation of Article 8 in relation to a photograph of a child where the photograph was taken in public, posted onto Facebook without objection, but then lifted from its location on Facebook and used to illustrate the cover of a pamphlet published by an adoption agency. And the Strasbourg Court distinguishes between the taking of the photograph and its unobjectionable publication and the publication which is objected to. But I think the true ratio is that the mother's case was that everybody thought her child was an orphan when the child appeared on the pamphlet of the adoption agency. And the Strasbourg Court seized upon the false impression which that gave to people who saw the photograph and knew the individual's impression. But there are limits to this family life analysis. A case which ends up being called Rhodes when it goes to the Supreme Court, OPO and MLA, failed at first instance and in the Court of Appeal insofar as it relied on misuse of private information. It's quite a famous case where the musician, concert pianist Rhodes, I've got his first name, maybe Daniel Rhodes, anyway, a celebrated concert pianist, wrote an autobiography in which he revealed that he'd been sexually abused at school and throughout his childhood, and that had led him to, amongst other things, self-harm and a mental breakdown. And it's a very graphic and distressing book to read, but absolutely gripping and engaging. He and his son's mother had separated, and the mother brought in the name of the son an application for an injunction to prevent the publication of the autobiography, on the basis that learning these details, these distressing details of the father's life, would cause harm to the son. And there was evidence from a child psychologist that it would cause harm. So it was a strong case in many ways. But the claim in misuse of private information failed on the basis that, as Lady Justice Arden explains, not every bit of information relating to a family belongs to each member of the family. So this was information belonging to the father, not to the son, and therefore it wasn't a misuse of the son's information. It's a fairly narrow distinction, but enough to stop that particular claim. The misuse of private information wasn't renewed in the Supreme Court. It wasn't the subject of the appeal to the Supreme Court. The Supreme Court dealt with whether the injunction could be maintained under what we used to call the rule in Wilkinson and Downton, the tort of causing intentional harm, and held that freedom of speech considerations meant you had to recalibrate that tort so that it couldn't apply in certain situations such as that. Another case of privacy within the family is the decision of Roberts J. in the HI and others case. This is a case where, again, the real balance is between Article 8 and Article 6. Very private information about a vulnerable minor was revealed to professionals involved in care proceedings. They were contested care proceedings, and the parents' case was that the information the child had disclosed to the healthcare professionals was relevant to the outcome of the care proceedings. The judge refused to allow it to be used, essentially on the basis that it wasn't sufficiently important or relevant to the outcome of the proceedings to override the Article 8 rights of the child. But it's an interesting parent-child battle over privacy of the sort one can imagine becoming more prevalent. A similar approach to the limits in OPO and MLA or MPA emerges in one limb of the JR20 and Facebook litigation in Ireland. At first instance, Facebook was sued by a loyalist protester who was the subject of satirical postings by his political critics. As is often the case with Belfast litigation, where I've spent a lot of time in recent years, the religious aspect of the case adds a dimension which isn't always apparent to people like me who have no religion or no religious background. And so one important aspect of JR20 was that one of the postings revealed the religion of his children. He had been in a mixed marriage. He was Protestant and married to a Catholic. And so revealing the religion of his children, he said, interfered with his family life. And Facebook were found liable. As you probably appreciate, for an intermediary to be found liable, there has to be primary liability against the poster. So the holding is the poster is liable for misuse of private information by putting up information about the child's religion. When he asks Facebook to take that down, if they don't take it down, they become associated with it and are then liable. So the question in the Court of Appeal is, could the finding of misuse of private information survive? And in a holding which might not necessarily be followed in all common law countries, but was no doubt informed by the religious context in Belfast, the court held that one's religion, as much as one's identity and appearance, aren't private facets. Many religious people wear their religion on their sleeve, worship in public and the like, and they go as far as to say religion would almost invariably not be private information. As I say, I can see that playing out differently in other locations, but important for intermediaries to have some clear categories of information which aren't private. Last in the family cases, family sector, is Ali and Aslam against Channel 5. I don't really have time to watch television, I confess, but if you put on the TV late at night, as probably many of you know, you get a whole slew of reality television things where people follow police or ambulances or, in this case, bailiffs into situations. Ali and Aslam is about a program called Can't Pay, Will Take It Away. Apparently one of the biggest Channel 5 audience attractors, and it does have its merits. It has some strong educational content and is a campaigning program about debt and homelessness, but it does involve TV cameras following bailiffs into people's houses and filming their eviction. It was a claim for misuse of private information arising out of one such episode. It met with a rather cold reception from Mr. Justice Arnold at first instance. Cold in the sense of my client, Channel 5, felt the froideur of the Chancery Judge. But it's a very incisive and careful judgment, very interesting on the property rights of which surround eviction and the extent to which Article 8 is still engaged if your home is literally hanging by a thread as you're putting the plastic bags by the door. But the very interesting aspect of Article 8. It went on appeal in December and the Court of Appeal judgment is awaited. Am I all right for time?
Yeah, I think that's sort of 15 more minutes
15?
would be fine.
Absolutely fine. I'll stop at any time if you want me to. But, I'll go on a bit about internet intermediaries. David mentioned the first case, CG and Facebook. CG also has strands about the protection of those caught up in the criminal justice system, but here it's a convicted person, not an arrested or suspected or charged person. And the importance of CG, when you come to think about the case of NT1 that David said you're going to be reading about next week, if you haven't already done so, is that CG's conviction was one that could never be spent because he'd been sentenced to 10 years. Whereas the NTs, of course, and the core problem is that their convictions were spent. So another issue which receives different attention in Belfast from London is the topic of child sex abuse and its link to religious divides, and as I'm afraid I learnt in this case, it's linked to paramilitary activity. I hadn't known, I don't know if any of you know, that the paramilitary groups physically punish convicted sex offenders in some instances to garner community support. And so being outed as a sex offender in Belfast can have rather serious consequences. So this man, CG, had been sent to prison for a sentence which meant his conviction could never be spent. A man called McCloskey ran a naming and shaming site, a site which said, X now lives at 42 Mill Lane, I suggest you all pop round with the baseball bats as he's coming home from the shop, and other quite charming things like that. McCloskey was the second defendant, but wasn't really worth suing, so the critical thing was whether Facebook could be liable. So the postings in question involved the man's photograph, which was lifted from the press at the time of his conviction, his name, details of his convictions, and then, critically, the area where he was living. The other thing about Belfast is it's very small. The claim was upheld at first instance. Mr. Justice Stevens held, by analogy with the data protection legislation, each of those subjects, each of those types of information was private information, and therefore Article 8 was engaged, and because of the nature of McCloskey's site, there was no scope for any realistic balancing exercise. And the case was really about notification. Had Facebook been notified in a satisfactory way of what was actually the objectionable content? Answer, to a large extent, no. Because the first three categories of information in the case of an offender whose conviction is not spent are not private. Full stop. However, they can be private in conjunction with details of where the person is living, because that can give rise to a risk of attack. But CG's lawyers, I'm afraid, didn't distinguish themselves. They complained to Facebook that the postings were defamatory, which is a bit of a bad point. They then complained of categories 1 to 3 indistinguishably, and although they attached multiple screenshots of this stream of bile on McCloskey's site, they didn't point to the postings which referred to where he lived. And so the Court of Appeal in Northern Ireland set aside 9/10 of the first instance order because the notification didn't sufficiently bring to Facebook's attention the unlawfulness of the relevant content. Only one letter very late in the piece made the connection between his place of residence and his past. I don't know whether it's on the syllabus here to look in detail at the e-commerce directive and the way it works, but it should be. I'm sure it is. But the Article 14 hosting protection was what was in issue, and the question of the apparent unlawfulness, which in a case like this is only dependent on notification. It's a critically important case for intermediaries, though, for two reasons. One is it establishes that you can have no constructive knowledge as an intermediary. So the first ground the judge had upheld the claim on was that there had been another claim by a different sex offender against McCloskey notified to Facebook, and he held that after that Facebook should have monitored McCloskey's postings, should have basically stepped in to prevent proactively the posting of this sort of information about others. The Court of Appeal said that simply doesn't work on the wording of the directive. Second critical holding right at the end is the holding that the e-commerce directive safe harbours apply to data protection claims. There's a recital and an article in the data protection directive, I think, or maybe the e-commerce directive, which suggests that they're mutually exclusive, and so that the e-commerce directive doesn't protect intermediaries against data protection claims. That would be a disaster for intermediaries because all they do is process data and they don't know what it is. I made my submission to the Court of Appeal in semi-classical language. What did I call it? My Oedipus and onanism submission. And they started to smile, and I said, every third word on Facebook is motherfucker or wanker. Those are both sensitive personal data. If there is automatic liability for that, then the whole edifice will crumble down. Sat there quite straight-faced for a minute and then burst out laughing. It was a great relief to me. Made the point. Facebook have been at the cutting edge of a lot of this, largely in Ireland so far, but this one is in the south. Mwema was an African lawyer who had been the subject of disciplinary proceedings. He had made what turned out to be the mistake of defending himself online. And so when he asked for an interim injunction requiring Facebook to remove postings making allegations against him of misconduct, one reason the judge refused was because he had entered the fray. He'd defended himself, brought publicity to the allegations, and that's something which is still works its way through in the later cases. Back to JR20, I've told you about one limb of it, which was the children's religion. The other limb of liability at first instance was a post which referred to him as a tout. My American clients found this absolutely baffling because it was a picture of JR20 holding up a large trout which had been caught in one of the locks. And it was one of a series of satirical posts. So it said underneath the picture of him holding up this trout, "It's a tout, so it is." Now, tout has a very specific meaning in Belfast. It means police informer. But understandably, the folks at Facebook thought it looked like a play on words, and it appeared in a series of other highly tasteful postings saying things like, this of course is just, "I'm not gay, but my boyfriend thinks I am." It was that level of humour. So Facebook's argument was that this was jocular and no one would take it seriously, but the power of the word tout in Belfast is such that the Court of Appeal upheld that head of liability, and effectively tout is therefore now a forbidden word on intermediary platforms in Ireland, which is quite an interesting result. Don't know what you do if you're writing about ticket touts. Yes, then the other reason, the point about JR20 is the notification under the e-commerce directive. There have been solicitors' letters, a bit like the CG letters sent to Facebook by JR20's lawyers. Those were held not to be sufficient notification because they complained largely of posts that weren't held to be unlawful, posts of him holding flags in public places, that sort of thing, which obviously aren't actionable. But later, they got an interim injunction, his lawyers, and that was served on Facebook, and one post it identified as the tout post. And therefore, for a short period of time after service of the injunction, they were held liable. Tamiz is the internet intermediaries' favourite case. It's the Strasbourg court distinguishing Delphi. Delphi is the one about the news aggregator, the news publisher who puts its own content up. They are liable without the e-commerce directive protection. But there's an observation that can't apply in the case of social media, and an observation that my clients really love about the reality of internet users posting comments every day, which no one would ever take seriously. I suppose they love it and hate it, but one can see from a legal liability perspective it's an extremely helpful comment. Sabados, this has been in the news recently, not this case, but there's a new industry, online funeral parlours, I think they're called in the States. People who will take down your loved one's online presence for a fee. So Sabados is a case where the deceased had more than one person they were close to. The claimant was either the wife or anyway, I can't remember which way around it was, but one of the two persons close to the deceased sought to access Facebook data of the deceased on the basis that it constituted her own personal data and that its deletion might constitute a breach of the DPA. It's an interesting case, never went further than a Norwich Pharmacal order, but it's, perhaps I should have put it in the family section, it's an interesting observation on the way one's data may be shared with others or interact with others. Then, last on intermediaries, there are some crucial cases pending in the CJEU. There are two cases against Google in relation to the RTB, the right to be forgotten, both referred by the Conseil d'État in Paris, and the AG's opinion in both came out on the 11th of January. The really big question, the right to be forgotten, which you won't get from NT1 because it ultimately wasn't argued at trial, was whether there's strict liability for sensitive personal data, because there's no processing condition, and so that was a real risk. That's the subject matter of the first of the two conjoined Google cases, and the AG's opinion holds that there's no strict liability. The second is about geographical scope. If you take down, do you have to take down in the individual European state, the whole of the EU, worldwide? And it was very hotly contested by Google, the suggestion that they had to take down from google.com in the States, people accessing information under different legal regimes. The Advocate General's solution is that you take down, this is what Google does at the minute, you take down across the whole of the EU because there's a harmonised data protection regime, and that seems a sensible step. And also, geo-blocking, which for a long time got no traction in court, was described by the Advocate General as a sensible and effective way of limiting the geographical scope of the order. Second is a case, shamed I couldn't instantly put my hand on her name when I was preparing this slide, but there's an Austrian politician who's was the leader of the Green Party, and her name is Glorwinish Pajak, I think. She was called by a Facebook user a miserable traitoress and a member of the fascist Green Party, sort of political abuse that's pretty much run-of-the-mill in this country, and one's rather surprised to find that it's unlawful in Vienna, but it is. And Facebook were ordered to take down not only the initial posts, but, and hear this, any post with equivalent meaning on the whole of their site. So miserable traitoress. any equivalent words across 2.7 billion users. Anyway, that was heard in the CJEU last week. Same Advocate General, interestingly, as in the Google cases. Right, last leg, the overlap with the DPA. This is perhaps the most interesting thing. David mentioned the stunt case. Stunt is a challenge to the second half of what was Section 32 of the Data Protection Act 1998. The automatic stay for data protection claims in relation to pre-publication journalistic processing. And if you read the parliamentary debates annexed to the Court of Appeal judgment, you'll see how strongly Parliament felt at the time it was enacted that there had to be protection against, for example, subject access requests by people like Robert Maxwell or other their modern-day equivalent. At first instance, the question was, I should say, is that total removal of pre-publication journalistic processing from the grasp of the data protection legislation compatible with the directive? The effect of the provision is there is no judicial consideration of the balancing exercise. The processor effectively does the balancing exercise, makes its own decision, and on its say-so, there is a stay. It's clearly what Parliament intended, so you're in a very difficult area of law where the courts are in what Ravinder Singh recently called deep constitutional waters, if you're going to set aside, as a judge, deliberate legislation which creates a deliberate result. Mr. Justice Popplewell, at first instance, found that it wasn't inconsistent with the directive. The Court of Appeal split, the Master of the Rolls and McFarlane agreeing with Popplewell, and Lady Justice Sharp finding that it was incompatible with the directive. And because they were unable to agree, they thought the matter wasn't acte clair, so it's been sent off to Europe in what may be the dying days of our CJEU practice. I'm acting for Associated in that case, and one argument that we have is that the Finnish data protection legislation is even more protective of pre-publication journalism than our own, and that has recently been considered by the Grand Chamber of the Strasbourg Court to strike an acceptable balance. But it's an interesting question. Your next week's reading, if I've understood David correctly, the right to be forgotten cases. Interesting cases in this field because they involved good old-fashioned cross-examination and the judge taking a view on the position of the two claimants and their meritorious or otherwise aspects of their claim. NT1's case, as you'll see when you read it, was dismissed on what was ultimately a straightforward Article 8, Article 10 balancing exercise. But the really interesting question is the extent to which Parliament already put a steer in that balancing exercise by the Rehabilitation of Offenders Act. Both men's convictions were spent. That the Rehabilitation of Offenders Act gives a degree of protection, which is obviously based on rights balancing. Acute argument is how much is left. In a sense, it's a twilight case, because I think I mentioned earlier, the real worry for Google was the suggestion of strict liability for sensitive personal data. But the right to be forgotten is now in Article 17 of the GDPR, and it expressly covers sensitive personal data. It's the same test, whether it's sensitive or non-sensitive. Sensitivity is just a factor. So the case is important and erudite, but it's the next right to be forgotten case is likely to be under the GDPR. There was going to be an appeal, but it didn't ultimately proceed. Last case I'm going to mention is Lloyd and Google. You've probably come across Vidal Hall and Google. Vidal Hall's a case about liability for setting cookies on Apple devices without consent, overriding the privacy settings. In Vidal Hall and Google, 4 individual claimants who had suffered bespoke or individualized distress because of what had happened. What happens is basically you get unwanted tailored adverts, And depending on your interests and how private your interests may be, you might find those tailored adverts popping up in business meetings when you check your phone and things like that. So it could matter. But in Lloyd and Google was a rerun of the same facts, but on behalf of 4.5 million iPhone users, none of whom had an individual claim. They had generic claims for the infringement of the data protection right. And Mr. Justice Warby refused to allow service out of that claim on the basis that the Data Protection Act doesn't give a right of compensation for a mere contravention. The Section 13 speaks of damage resulting from the contravention. Therefore, you have to have both the contravention and damage. And it also on the basis that the Victorian, in fact, the least Victorian representative action proceedings, now found in CPR 19.6, don't cover mass claims for damages. If they did, we'd probably have had class actions before, but the argument is that that rule should be adapted to modern conditions, can provide for a class action in the data protection field. One difficulty of the argument is Parliament has provided for class actions in some fields. So there are competition law class actions. There aren't data protection class actions. There may be under the GDPR, but only if Parliament, after consulting, decides to bring them in. So this is an accelerated attempt to achieve through judicial creativity a class action that Parliament's actually considering at the minute. Going to the Court of Appeal, listed for July. Thank you very much.